My name is Mike Dressler, and I'm the Bergen County Surrogate. For those of you who don't know, Surrogate is one of the 3 constitutional offices in the state of New Jersey, along with the county clerk and sheriff. And it's a job and position that goes back to the 1600s. When the British decided they wanted to record wills, they appointed a surrogate to do that. When they came to this continent, they kept that position. And when this nation became a nation, they instituted the office of surrogate. At first, it was appointed by the governor, then by the legislature. We've been electing surrogates at large in New Jersey in each county since 1854. The only elected judge in the state of New Jersey. All other judges are appointed. It's for a 5-year term. Now, the word surrogates derived from a Latin term, and loosely translated, it means one who stands in the place of another. And a lot of the job functions that we do in the office, we do just that. We stand in the place of another. We probate all wills in Bergen County. If someone dies without a will, we appoint an administrator for their estate. We oversee the operation of all estates. We also get involved with adoptions, guardianships, incompetency hearings, and we invest money on behalf of minor children who, as a result of a lawsuit, have recouped money damages. That money is placed into our account. It's invested by my office, and when the child reaches the age of 18, the money plus the interest that is accrued is returned to the child. Right now, we're investing about $20 million on behalf of those minor children. And of all 21 counties in the state of New Jersey, I'm pleased to tell you that Bergen County is receiving the highest rate of return on our investment of any of those 21 counties. So I'm quite happy about that. What I want to do for a few moments today is talk to you about some documents that everyone here should have in anticipation of the future. That's a will, a power of attorney, and an advanced medical directive living will. We'll go through them one at a time, explain briefly what they are, and show you why you should have that particular document. The first one is a will. And I guess of the 3, that's the one that people are most familiar with. One of the things you can do within a will is set out your executor. That's the person that you've chosen to oversee the operation of your estate when you die. Now, the good portion about all these documents is you have the unbridled ability to do whatever you want within them. So whoever you feel best qualified to act as your executor, you can appoint to that position. The main thing we do within a will is we distribute our property in any fashion you see fit. There are no restrictions on what you can do within your will with your money and property. So if you want a person to get a single item, a fixed percentage, a certain amount, or the entire estate, whatever you want to accomplish, you can accomplish in your will. Before I became surrogate, I practiced law. And I'd say maybe 95, 97% of the people who came to see me about a will wanted to create a husband and wife situation. That's one in which everything the wife has goes to the husband, everything the husband has goes to the wife. If they both die and they have children, it would go to the children after that. And most people expect a scenario very close to that to take place when they die. Well, it's not necessarily true. If you die in the state of New Jersey without a will, the laws of intestate succession come into play. And what they are, they're very specific tables that indicate who will have priority in being appointed the administrator of your estate. And it may be someone you don't want in that capacity. It also indicates where the money and property from your estate is going to go. And it may indicate it's going to someone you wouldn't want to get that money and property. But there is absolutely no discretion. Whatever those tables indicate, that's where the money and property will go. Now, I'll give you a case in point to show you what could happen. Happened to my office a while ago. I had an attorney come in one day. He doesn't do estate work, he does criminal work. His friend had died, and he was helping his friend's wife go through the administration of the estate. So he came in for some pointers on how to go about things. We sat down, we talked for a while. First question I asked him, what was the approximate value of the estate? He told me it was somewhere between $12 and $15 million. I asked, yeah, a little less than I make a year, but it's not bad. I asked him, under the terms of the will, who was going to be the executor? And under the terms of the will, where was the money and property going to go? He told me that there was no will. Well, because there was no will, these laws of intestate succession came into play. There were no children born in the marriage. And those laws of intestate succession indicated in this particular case that the wife in this matter got just 50% of the estate. The other 50% went to the gentleman who died's father. So because her husband never drafted a will, this woman's out $7.5 million. It's also normal for an attorney to place into the body of a will a clause that indicates that the executor not be required to post a bond. We usually require a bond as an insurance policy to make sure that the will is carried out in accordance with the testator's wishes and in accordance with state law. There was no will, so obviously no clause to that effect. So in addition to losing, we'll round it off, we'll say $7 million. This woman has to post a bond for another $7 million. Pay the insurance premiums on that bond up front and keep it in place for every year that the estate is in place. $7 million. She's got to pay the insurance premiums on this bond and keep it in place for every year that the estate is in place. So if it takes 2 years, she's paying the insurance premiums on a $7 million bond for 2 years. So you can see it can become very expensive if you don't have a will. Now the will has changed over the last several years in New Jersey. It used to be that you would sign a will, that will would be witnessed by 2 people. At the time of your death, the executor would have to bring the witnesses in. The witnesses would testify that they had seen the will signed and that you were in fact the person that signed the will. Well, this is a more mobile society than was 40 or 50 years ago. Situations change, people move, and unfortunately they die. It became increasingly difficult to get the witnesses into the probate department. So the state changed the law, and they now allow what's called a self-proving will. Self-proving will, you still sign it, it's still witnessed by 2 people. After that, it's notarized by a notary public. There's also a self-proving affidavit placed into the will. Once that's done, it alleviates the need for your executor to bring the witnesses in. The clerk takes the document, see that it's signed, witnessed, notarized, looks for the affidavit, admits it to probate as a matter of course. Much simpler, much less costly than the old system. Under the old system, if the witnesses could not be provided, if they had moved and couldn't be contacted, the only way to admit that will to probate was to get an attorney, file a complaint in Superior Court, have a Superior Court judge make a decision to admit that will to probate. So it's much simpler nowadays. Second document is called a power of attorney. And what a power of attorney is, it's a document that gives you the ability to choose who you want to care for your business affairs and what types of business affairs you want them to care for. You can choose anyone you want to have your power of attorney, and you can place any type of business affair you want into the document. Now again, you can choose, whoever you feel best qualified. There are basically 2 powers of attorney that can be utilized. It's called a general power of attorney. General power of attorney, you sign it, you give it to the person you've chosen. They have the ability from that moment forward to control your business affairs. If you become incapacitated and can no longer make your own business decisions, that power of attorney would stop upon your incapacity. So at exactly the time most people want a power of attorney to start, the general power of attorney stops. So what you really want to be looking at is what's called a durable power of attorney. Durable power of attorney, you can choose anyone you want, any type of affair you want, you can put it into the document. The good thing about the durable power of attorney is it can be drafted one of 2 ways. It can be drafted so you sign it, you give it to the person, they have the ability from that moment forward to control your business affairs. If you become incapacitated, you can't make your own business decisions. That power of attorney would continue through your incapacity. Or it can be drafted so that it only takes effect upon your incapacity. So you continue to hold your own power of attorney should you become incapacitated and not able to make your own business decisions. That power of attorney would start upon your incapacity, which is really what you want. Because if you don't have the power of attorney in place and you become incapacitated and not able to make decisions, the only way to have somebody in place to make those decisions would be by way of a guardianship. And you have to get an attorney for that, you have to go into Superior Court, and it's going to take a lot of time and a lot of money. So you want to have the durable power of attorney in place to make sure that if something happens to you, you're covered, you can pay your bills, your mortgage, your taxes, things like that, okay? And please, with all of these documents, go to an attorney and get them done right. People say, well, there are things on the internet, there are forms that can do it. No, you want to get it done by an attorney, and I'll show you one of the reasons why. With an attorney, you're getting feedback. They're going to ask you pertinent questions about your estate, about your affairs, things of that nature. Anyone who has a child or an adult who has physical or developmental disabilities and is receiving subsidies from the government, it's extremely important to impress on that family the need not only for a will, but a special needs trust within that will. Okay, the person who's receiving the subsidies, that is predicated upon income. If that person receives a lump sum payment from an estate, it's probably gonna put them over eligibility requirements. They're gonna lose their subsidies, and then they're sunk. What you wanna do is have the special needs trust so that they'll receive their subsidies, they'll receive an income from the trust every year that doesn't put them over eligibility requirements. They'll have the best of both worlds. If you're looking at a computer and you're looking at a form, they're not asking you that question. An attorney will. So go to an attorney, get these done, get the feedback, and have it tailored exactly the way you want it to be tailored. Now, the last set of documents are called an advanced medical directive living will, where the power of attorney gives you the ability to choose who you want to care for your business affairs. These documents give you the ability to choose who you want to care for your medical treatment and what type of medical treatment you want or don't want. You can state very simply with the advanced directive, I want so-and-so to make all my medical decisions. Or with the living will, you can enumerate each and every type of medical treatment you want or don't want. I want to be put on a feeding tube. I don't want to be put on a feeding tube. I want to be put on a respirator. I don't want to be put on a respirator. Whatever you want, you can place into the document. Now, the living will only comes into play in a terminal or serious situation. That's described by law as having less than 6 months to live. So if you go into the hospital for something routine, absent something seriously going wrong with you in the hospital, the living will not come into play. If it's terminal, it seriously will. Hospitals nowadays are required by law to give you a living will when you go into the hospital. First question they'll ask you is, do you have a living will? And can you provide it? If you say no, they'll ask you if you want to sign a living will. Two problems with that. Number one, they're asking you to make life and death decisions on the spur of a moment. You really should be able to sit down, go over it in your own mind, talk it over with your loved ones, so if and when the time comes, there are no questions about what your wishes are. The second problem is, we don't always go into the hospital in a condition able to sign a living will. If you go into the hospital in a coma, you can't sign a living will. If you go in such excruciating pain you can't make a rational decision, they won't let you sign a living will. So again, go to an attorney, get these documents done, have the peace of mind of knowing that what you want to happen with your medical treatment in the future will in fact happen. Now, nobody here is interested in taxes, are they?
No.
I didn't think so. All right. The situation with taxes after death in New Jersey has changed over the last few years. You remember the gas tax, where we paid more money on the gas tax?
Yeah.
Well, there was some good news with the gas tax rise. And that was that one of the estate taxes in New Jersey was done away with. So we only have 2 taxes now in New Jersey. We used to have 3. And the tax that was done away with, it was a very complex set of calculations, and it could cost you upwards of 30% of your estate. Okay, that's done away with. After death in New Jersey now, there are 2 taxes. In New Jersey, we have what's called a transfer inheritance tax. Tax is determined by who gets the portions of the estate. If you're a Class A beneficiary, husband, wife, child, grandchild, stepchild, there are no tax consequences to you from the state of New Jersey. If you're a Class C beneficiary, B was done away with. C, your brothers and sisters, you're taxed at 11%. Nieces, nephews, aunts, uncles, cousins are taxed at 15 and 16%. The federal government taxes you differently. They tax you on the size of the estate. Present day 2021, if your estate is less than $11.5 million, there will be no federal tax to you. If it's over $11.5 million, I'm available for adoption.
What?
So those are the 2 taxes after death right now in New Jersey. So the other one was done away with, the more costly one was done away with. So we got a little break that way. Now, I'm going to ask Mercedes, you want to pass out those booklets? These booklets we've published a number of times over the last several years. This is the most recent information possible. The very last thing in my booklet is an address and phone number. If after I leave here today you think of a question, give us a call. We'd be glad to talk. Okay? If anybody has any questions now, I'd be glad to answer them for you.
Thank you.
Okay?
I'm broke. I have nothing. I live on a fixed income, get my social security, amend it because there are a lot of things that I was able to pay before, I can't pay now. So why do I need to have a will?
Now, do you own anything that you would want somebody else to get?
No.
No jewelry, nothing like that? Okay, who's your closest next to kin?
My daughter.
Your daughter, all right, so she would get anything, so you probably, if you don't have anything, then you probably wouldn't have to do it.
That what?
You probably wouldn't have to do it.
Right. But is she gonna get taxed for anything for where I live or she's
Sure.
getting, if I have nothing, they can't tax
she's-
her, right?
Right, she's a daughter, so even, no matter, if you had money, she'd be free from the transfer inheritance tax because she's a Class A beneficiary. Your estate is not over $11.5 million, so she's not gonna be taxed.
Uh-huh.
All right? Yes?
Is it necessary to have the will probated? Like, my wife died 6 years ago and left everything to me, and there's nobody to contest anything. And I had my will redone a few months ago, and my attorney said that I should have the will probated anyway to prevent any problems with the
Did you have,
I don't understand.
did you have a house?
Yes,
Was it in both names?
yes.
Okay, so at some point, what's gonna happen, God forbid something happens to you, okay? That house is gonna be transferred to someone else, right? Now it has to be transferred from your wife's estate to you, and then from your estate to someone else. So, you know, with regard to the deed, you know, you wanna change that at some point, okay? Now, did your wife own anything in her own name?
Everything was jointly.
Okay, so at some point, you wanna have the deed changed over to make things easier for whoever is gonna receive your estate. Okay? Should it be probated if everything's in both names? Was the car in both names?
Yes, but that's been taken care of.
Okay, then you don't have to probate it. But at some point, I changed the deed and, changed the deed, from your wife's estate to you.
Now, I put in the will that the house be sold
Right,
and that the proceeds go
Right.
into the general
Right.
fund.
right. Yeah. Yes?
So question, in a similar scenario, the husband passes away and without a will. So I'm assuming everything reverts to the wife, there's no parents.
Yes.
Okay, and then what happens if, say, tomorrow,
Well, let me ask you a question.
Yeah.
Not necessarily, yes. Is it, do you have any children?
Yes.
Did the deceased have any children?
yes,
Were
they're
they?
mutual children,
They're mutual children.
Yeah.
All right, then you don't have a problem.
okay.
Let me just explain one
So,
thing.
just the second part of my question is, if for some reason I were to go before I transferred the deed, because the deed is still in both our names, it's been many years since he's gone, would my kids still get the house?
They get it, they'd have to come in and probate the estates, both of them.
Mhm.
Yeah.
But it would obviously all go to them, it
Yes.
wouldn't be taxable to them,
No.
okay.
Now, let me just explain one thing, because, things get complicated. In the state of New Jersey, if the deceit, your spouse dies, and your spouse had children from a first marriage, okay, and you do not have a will, you will get 50% of that estate, and the children from the first marriage will get the other 50%. Your children from the second marriage will get nothing. Because there's a presumption that when you die, your children are gonna get your 50%. So that's why I tell people, go out and do a will. There are problems if you don't have a will. Please, go out and get one, and avoid the problems that could happen down the road. People don't have any idea, what the ramifications of not having one done. They're terrific.
Can you just clarify, you mentioned earlier where the guy had millions of dollars.
Yes.
Why was his father, rather than just his wife, entitled to?
That's the way the law was written at that point.
Is that still the law?
No.
or-
No.
So if that had happened today, the wife would have gotten everything?
Yeah, depending on the child situation. Yeah. Yes.
I want to have, people like your college be on. And I thought that that's the time that they in the hospital would do that. But if one of my 3 children doesn't agree with it, they can fight it and keep going.
If you've signed a document that you don't wanna be on a resuscitator, they can't put you on a resuscitator. And if somebody has a question about that, you wanna get the attorney involved, and the attorney that wrote it up will call the hospital. And if they don't do it, they better have a good malpractice policy.
But it's important to like just,
Stipulate everything that you want. Okay?
do I have to do it every time I go in the hospital?
No, you should do it now. You should do it now. And, with regard to the living will and the advance medical directive, you wanna give copies of that to everybody. No, you do. You wanna make sure that people know that you've got them. If it's sitting in a drawer in your house and no one knows about it, it's not any good. So you should give it to, your spouse, you should give it to your kids. If you've got a particular doctor that you use and they has the ability to hold on to it, that should happen. Your ambulance corps in town, if they have the ability, again, to hold on to it, and file it, they should have it. You've got all, in the booklet that you've got, the blue booklet, everybody got a white packet in there? Okay, you take that out, we put together in the surrogate's office a while ago, so just hold that there. Okay, everybody see it? You see the blue patch on there? Okay, yeah, the blue thing you can take out and put it on your front door. Okay? Now that will alert the EMTs should something happen to you, that you have your medical advice, on your refrigerator. The plastic packet you can put on your refrigerator. Now inside the plastic packet are 2 sheets, and you fill those sheets out, you put them back in the packet, and that's all your medical history. So that the EMTs, they'll see the blue sticker on the front door. They'll know that this is on the refrigerator. They'll come in, they'll get the medical history. They won't have to ask you any questions. If you're unconscious, they'll be able to, know exactly what the problem is by looking at the sheets and get your medical information. All right?
That's a good idea. Very
My daughter said to me,
Yeah, but, the EMTs, when they come in, if they see that blue sticker, they'll know to go to the refrigerator, will have all your information right in it. Yes, ma'am. Yes, ma'am.
if I have on New Jersey resident, but I have property in other states, do I have to pay for probate on those states?
What-
Or
what-
vice versa?
You live in New Jersey, they will do what's called an ancillary proceeding in the other state to free the property up. It's not a big deal, it's done every day.
But what about, I claim New Jersey as a primary resident.
Yeah, it's-
My husband is New York resident.
Well, it's still, whoever dies, if he dies, then it would be probated in New York. If you die, it would be probated in New Jersey,
Okay.
all right? And they would do an ancillary proceeding in the other state. Anyone else?
I have one more question to ask. My husband says he wants to be cremated when he dies. Is that something that needs to be put in a will?
No.
How you
He
want
can
to-
have it, he can sign a letter of direction and keep it with the will. Because you can't probate a will until 10 days after death.
Right.
Okay, so, you can't bring the will in for 10 days. So in 10 days, he's gonna either be buried or cremated. So keep a letter of instruction that he wants to be cremated.
Do I have to follow the instructions?
Do you have to follow his instructions? Technically, no, you don't. But technically you don't.
Because, I'm Jewish and I don't believe in cremation because he's Seventh-day Adventist. And he believes in it. And mentally, I can't handle having to make a decision to cremate him. And so, I know it's a weird situation.
Well, let me ask you a
I'm
question.
putting in my will that I won't be compensated.
You obviously want to be buried.
Yeah.
Okay, now, if you want to be buried and you go first, and he says, well, I'm a Seventh-day Adventist, I'm not gonna bury her, I'm gonna cremate her, would you like that?
No.
Okay, so then do what he wants on his.
You're speaking for him.
Yep. What's good for the goose is good for the gander.
Then again, we're not gonna go.
I'm just not gonna die.
I wanted to add something to your wonderful discussion, because I did this with my family many years ago. When you get the medical directive and you start filling out what you believe for you, and then you give it to somebody, in this case it was my daughter, and then she had to fill it out the way she thought I would fill it out. And she knows me very, very well, very, very close. She got half of them all. So it's a very important discussion, as you said, so that people really know what your belief system is.
Yeah, you've gotta sit down. If you go into the hospital, you got a problem, and they say to you, you wanna sign a living will or an advance directive, they're asking you to make a decision right then and there.
Yeah.
Sit down, go over it with your family so they know. Because it's a tough decision for families to make, especially if the decision is, that they're gonna take life support. It's a very, very tough decision, so sit down, let them know what you want.
And it's also a problem because a lot of people at a certain age, if they don't have a will, they are very, very afraid to make a will because they think that it means they're gonna die. And they don't wanna die. And everyone wants to live. No one wants to die.
Interesting point for Pam, who was questioning if she needed a will. When I took care of my mother's will, because I was the executor, there were things I couldn't have done without her making me executor, such as closing out her apartment, and I got the security back and shared it with my siblings and so forth and so on. There were just tiny little things that you just don't think about, that the will makes easier,
Yeah.
even if you have not one penny.
Anyone else? Going once? Every time I do that, somebody pops their hand. Every single time I do it, somebody pops their hand. Go ahead. Yes, ma'am.
I was a displaced person when I was born, when I was a baby. And I essentially did not have a birth certificate until I was in my teens, when I finally wrote a letter to the country to get my birth certificate. It was a baptismal certificate. It turned out that I was celebrating the wrong birthday, and my name was totally different. Now, I came over with my family, and my name was slightly different also. Would there be a problem as far as my husband had to collect some of the monies from the birth to the other? Because like right now, my name is the same as my passport and my driver's license and everything. Is there a
Have
foggy thing there?
you changed your name?
My name is not since I have my passport or anything like that, but in the beginning, I didn't even have a birth certificate.
Right. Now, as things stand now, are your names the same?
The name is the same as it's not the same as my birth certificate name.
Okay, you might wanna talk to an attorney and make sure that everything's changed to coincide with, what you're using now,
Okay.
just to make sure. I mean, with regard to a will, it's probably not gonna affect things, but there are other things that could be affected, so you probably wanna sit down with an attorney and talk to him about it. Make sure that everything, is the same way. Right? Yes?
And what are the typical charges that an attorney charges somebody for doing a will?
It all depends, I mean, depends, first of all, how much goes into a will, and depends on the attorney. Like everything else, you should shop around. You wanna find somebody that, does this type of work, and you wanna shop around. A good source is the Bergen County Bar Association. They have a referral service. They give you the name of an attorney, and I think it's $30 or $40 you pay. You get the name of an attorney and a consultation with them. It's not a bad way to go. But, attorneys are like everything else, they all charge different prices. So you wanna shop around and get somebody that's good.
Did they ever do pro bono? Do other attorneys who do pro bono?
It's hard to find an attorney on pro bono, attorney for an estate on pro bono. But, talk to the Bar Association, they're in Hackensack. Okay? I think I had somebody over here. Yes,
How
ma'am?
do you find an attorney that would be reasonable if you didn't have that kind of money to spend?
Because I'm a judge, I can't recommend an attorney
No,
to
I
you.
know, but I'm just trying to find out where you said to find one.
The Bar Association,
Or association.
yeah. Anyone else? Yes, sir.
Okay, so when you pass on and you have a will, how does it work with your office? Does the will go to you, or what
Yes.
is the
10
process?
days, 10 days after death, the executor listed in the will can come in and probate the will. So they would bring the death certificate, they would bring, the will itself, the original will. And by the way, you can only probate an original will. You can't probate a copy of the will. So if you don't have the original,
So
make
the
sure.
executor sends it to you 10 days later?
Yes, and
Within
then.
10 days?
Yes, and then we take the documents. You can do it either in person or remotely at this point. We changed the system last year with COVID to do things remotely. So you can either, bring it in and have it probated or do it remotely. So we get the original will, we get the certified copy of the death certificate. We talk, we get some information from you. We prepare the paperwork, we'll have you sign the paperwork. Then we'll issue letters of testamentary. You'll get those, you'll take those, and you'll be able to marshal the assets, pay any bills or taxes, and then make distribution of the estate.
Okay, so you sign off on and send a letter to the executor?
No, the executor would bring the will and the certified death certificate in.
To you?
Yes.
And is there a fee for your services?
Yeah, the state mandates what the fee are. They're not much at all. Yeah.
Hi, I have a will and the recipient robbed me while I was in the hospital, but I haven't taken her name off it. What should I do besides?
Go to an attorney quickly.
Yeah,
How you feeling?
I'm okay.
All right, then you don't have to go that quickly.
Excuse me?
Then you don't have to go that quickly. But you wanna take it to an attorney and have the attorney do a new will, take them out.
Okay.
Yes, ma'am.
Is Hackensack the only place that you can take the will to be recorded
You live in Bergen County?
in Bergen County?
Actually, we haven't used it in a while because of COVID, but we have a series of satellite offices around Bergen County. And we've actually got one in Fairlawn. So if you need to probate that will, you can call one of my clerks and my clerk will meet you in the Fairlawn, Borough Hall, or, if we can do it here, we can do it, right in the senior center if they allow us. All right? We have 10 of them around Bergen County.
If you have one in Bergen County, can it still be done in Bergen County?
No, you have to probate the will in the county you resided when you died.
Oh.
If you look in the back, you got the blue booklet?
Yeah.
All right, there's actually 11 sites. You look in the back of the booklet, and that'll tell you where the sites are, the satellite offices. All right? Yeah.
if you had a will made, 25, 30 years ago, and I went maybe 2 years ago to the office of the attorney who had become a judge and no longer practices, but his brother does. And I wanted to do something, or ask a question about the will, and they told me they can't find the will. I have it. Do I have the original, or do they have the,
You should have the original. Okay, check to see if there's a notary stamp on there, and if you can feel the perforation from the notary. Okay?
and that means that's the real
That
one.
means it's the original.
And if it isn't, I'm in trouble, have to
You
do
wanna
it
have,
again.
you wanna have it drafted again.
Now, would they have to do it for me for free if I'm showing them the will and they say they don't have it?
No, any good attorney would give you the original and keep a copy of it. All right? Some
But I
attorneys.
should go there and make sure they make a copy of what I have and keep it on their file, right?
Well, you can't probate a copy, so the one you want to worry about is the original. So check to see if it's an original.
But shouldn't they have something to prove that they,
But you can't probate a copy.
right?
You can't
So it
probate.
doesn't matter that they don't have a copy.
Now, yes and no. Yes, no. Take a look at your will. Okay, you've got a question, give me a call, come in, I'll take a look at it and let you know if it's the original. Yes, sir.
No, I just wanted, does the will need to be notarized? I didn't hear that.
Yes, it's gotta be signed, witnessed, notarized. Okay? Anyone else? Yes, ma'am.
When you do the will in a lawyer, right, attorney, how you notarize? If you go to somebody else to notarize, you have to sign in progress.
No, the attorney will have someone in his office that will notarize it for you. Yeah.
That's one that.
Oh, yeah, they're well equipped. Anyone else? Going once? Going twice? All right, thanks for the invitation.
Thank you.
We do have some questions that were submitted, and one was just a general question about how COVID-19 affected the process of probates in general in Bergen County.
So what we did is we set up 7 email addresses, and you can see them on the screen right now. And you could direct your questions to the various departments in the surrogate office. We also devised a system where everything was done remotely. So you would go on our website, you would fill out the particular information sheet, whether it be for a probate of a will itself, or if there was no will, it would be the administration sheet. Once that was done, you would download that, send it to the surrogate office. My clerks would take the documents, begin to the process of the probate itself. They would get all the information together, fill out the paperwork, then they would send that back to you. When you had it, they would work things out so they could remotely have you sign, you send back the original documents, and the probate process would be finalized. So it was a system that's worked pretty well. It took us a while to get things up and running, but we did it within a month, and it's worked incredibly well.
And the next one is another one that you've partially answered, but there are some minor things in here that might change your response. So if my annuities and IRAs have designated beneficiaries, and if I have no preference as to who receives my personal possessions, can I simply provide a signed statement that I want the equity in the residence, balances in bank accounts, and positions in equity trading accounts be divided equally among my children rather than have a last will and testament?
Okay, let me take that in 2 parts. Number one, the IRAs and things of that nature, life insurance, they're contractual obligations. They do not pass through a will if there's a beneficiary. Okay, so if they have the beneficiary in the life insurance, 401k, things of that nature, it does not pass through the estate. Number two, the answer is no. You can't just simply do a letter. What you need to do is do the will. It can be in your own hand if it's witnessed and notarized, but you do have to do the last will and testament if you want to stipulate exactly who is to get the bank accounts, the equity in the house, and things of that nature.
Okay, thank you. The next question is, we assist two of our children by partially paying for school tuition for two grandchildren. How could that be handled in a will that divides the estate among three sons if my husband and I both died before these children were 18, completed high school?
Right, if you're gonna, it's again a two-part question. The grandchildren could be provided for their education by placing a trust into the will. If they're under 18, whoever is appointed as the trustee, and it could be their parent, would have the ability to control that trust while the child is under the age of 18. At the age of 18, the trust would then go to the child himself, okay, directly. The portion with regard to the children, that could be done specifically by other provisions in the will, just granting them the portions of the estate that the parent and grandparent wants them to have. So, if they want the child to have a third of the estate, each son to have a third of the estate, they could do that, but they could carve out a trust provision for a certain amount for the grandchildren to continue their education. But they would have to have a trustee for each one of the grandchildren also.
Okay, thank you. The next is a situation, a COVID-related situation. My brother died from COVID. I am his only heir, but there is no will or beneficiaries. As administrator, how should I handle his investment and stock holdings? Not all are IRA accounts, some strictly bank savings, but substantial amounts. He lived in Texas and recently Virginia. I am in New Jersey.
Okay. The will would have to be or the administration would have to be probated in the county and state that the decedent lived in at the time of their death. So at this juncture, he lived in Virginia at the time of his death. The administration would have to be done in Virginia. As to the investment of the particular funds, I am prohibited, because I'm a judge, I'm prohibited by court rule from giving any legal advice or financial advice. So unfortunately, I can't do that at this point.
Okay, thank you. And where would you suggest that this person then might be able to get answers to those questions?
I would tell a person to call the Bar Association in the county that their relative lived in Virginia. Ask them for the name of an attorney that does estate and probate work, shop around a little bit, and hire the attorney and do the probate in Virginia.
Okay, thank you. Okay, we have one more question. How current, it's a two-part question, how current does a will need to be, and how often should it be updated?
I tell people to look at their will every 3-4 years, just to make sure that situations haven't changed. People haven't died. They haven't decided to give portions of the estate to different people. A will could be good as long as the person's alive. You could have done a will in the 70s and it's still good, as long as everything remains the same. The only proviso is that if it's done earlier than 1979, you want to make sure that it's a self-proving will. Like I said before, self-proving will is one in which it's signed, witnessed, and notarized, and there's a self-proving affidavit placed into the will. If it's done before 79, it would not be self-proving. You'd have to bring the witnesses in, and there's a good chance that the witnesses may not be around from that period of time.
Okay, so we have another question that just came up in chat. Just to clarify, 401ks are not are outside of the will, is that correct?
That's correct. 401ks, life insurance policies, what you do is you take a copy of the death certificate, you send it to the particular company involved, and they will release the money to the beneficiary. If there is no beneficiary, then it would go through the estate.
Okay. Well, Judge Dressler, I thank you very much for joining us today. And
My
all the
pleasure, anytime.
information you offered, and as we have indicated previously, this has been recorded, and it will be available on YouTube as well as the local cable stations in Bergen County. And that has been our goal this year with North Jersey Villages, to reach those people, the isolated or those who just choose not to use their computers. So what we will do then is make these available, and we look forward to, if there are any further questions, I assume we've given information as to how you can be contacted in your office. And I know from your past history that you will be more than willing to respond to them and get back to anyone
Absolutely.
who has questions. So we thank you again.
That's what we're here for.
Thank you.
My pleasure. Thank you.
Have a great day.